So today in this class, we'll learn about the High Court. Though the Constitution of India has provided for a single judiciary system, yet there is a provision that has been made by the Constitution to have a separate court of each state. Okay, so like this, the High Court is at the state level, and High Court is the highest court in the state. And Article 214 of the Constitution states that there should be a High Court for each state. Okay, so accordingly, at present there are 25 High Court in India. Okay, and sometimes there is one High Court that is being shared by 2 or 3 states. Example, you could see at present there is a common High Court for the state of Punjab, Haryana and the Union Territory of Chandigarh. And similarly, there is a common High Court for Assam, Nagaland, Arunachal Pradesh and Mizoram. And Hyderabad High Court also shares with Andhra Pradesh and Telangana. And even the Bombay High Court shares with Maharashtra and Goa. So like this, some states they share with that means sometimes the states share with the 2 or common High Court with the 2 or 3 states. Okay. And regarding the number of judges of the High Court, okay, so there is no constitution, there is no fixed number according to the Constitution, but it has been left to the discretion of the President. So President has the right to decide about the number of the Chief Justice and the judges of the High Court. Okay, so High Court represents by the Chief Justice and other judges, and he is being appointed by the President of India. Okay. Among the appointment, who appoints these judges of the Chief Justice and the judges of the High Court? It is the President. The President of India appoints the Chief Justice and the judges of the High Court. Okay, so while doing this, okay, he consult, that is the President consult the Chief Justice of the Supreme Court and the Governor of the state. Okay, so the President appoints the judges and the Chief Justice of the High Court, and he does with the consultation of the Governor of the state and the Chief Justice of the Supreme Court. So now let us know about the qualification required to become a High Court judge. Firstly, he should be the citizen of India, and secondly, he must have served as an officer in the judicial office for at least 10 years. Or he must have served as an advocate for 10 years in one or more than 2 High Court in India. Okay. Otherwise, he should be an eminent jurist as per the opinion of the President. So these are the qualifications required to become the judge of the High Court. Next, regarding the removal of the judges of the High Court. So there is a provision, that means the Constitution has framed the Constitution provision to safeguard the service of the judges of the High Court. That means he cannot be removed. Once he is been appointed as a High Court judge, he can retire only after 62 years. If he find in any activity, that is if he misbehave or if he found he is incapable, the President can remove him from the power, but he has to do with the support of the Parliament. That means the Parliament passes the resolution, okay, and that resolution has to be approved by 2/3 majority of the members of the Parliament. Okay, so this is the norms that is required for the removal of the judges of the High Court. So now let us know about the powers and the functions of the High Court. Okay, it has original power, appellate power, administrative power and various other powers. Let us know one by one. So firstly, we will know about the original power. So as you have learned in the Supreme Court power and function, similarly here it states that original power means the High Court has a special power. That means it implies that there are certain cases which should be directly brought to the hand of, that means under the control of the High Court without being taken into the subordinate court. Understood all of you? There are certain types of cases which can be brought directly to the high court without being taken to the subordinate court. For example, the cases related to the fundamental rights. As you all know that the court, that means it protects the fundamental rights of the individual. If any such fundamental rights are been taken away, what they can approach, that means the person can approach to the High Court, and High Court protects the fundamental right of the individual by issuing the writ. Writ you have learned in the previous class, that is nothing but a order that has been issued by the court in order to protect the individual fundamental right. You have also learned about the writs like habeas corpus, mandamus and prohibition. So all these things have been passed by the High Court in order to protect the fundamental right of the person, that is of the people of India. High Court also has a original power in cases related to matters like divorce, will and special revenue matters, and the election dispute can also be taken to the High Court. And thirdly, the High Court can also declare unconstitutional if any law that has been formed by the state legislature or by the executive order of the state government, and which it finds anything against the provision of the constitution, then with that matter also the High Court has the power to deal with it. Okay, the next we have about the appellate power. Appellate power, as you all know that you have learned in the Supreme Court, that it also takes up the appeal. That means if you are not happy with the judgment given by the lower court, you can approach to the High Court. So even here also High Court has the power to take the appeal against the decision of the district court. Okay, so High Court has the appellate jurisdiction. That means it takes the appeal from the lower court against the decision issued on the cases like a civil matter and the criminal matter. Okay, so against the decision of the lower court at the district level. And all the cases involving the capital punishment issued by the session court also comes under the High Court. So apart from this original and appellate power, High Court also has the administrative power. So it has to supervise. That means the High Court has to supervise the working of all the courts, that is subordinate courts to it. Okay, and also the High Court has to make the rules and regulations for the court in order to see that they ensure the efficient working of the courts. Okay, and it also has a power. High Court also has a power to transfer any cases from one court to another court, and even transfer some cases to itself also. Okay, and High Court also has the power to determine the salary, allowance and other conditions of services to the administrative staff of the High Court. Okay, and High Court also acts as a court of record. As you have learned in the Supreme Court, that High Court maintains the record. That means it records the proceedings, activities and the judgment of special cases. Okay, this it does in order to see that the further, it means it can be referred in future cases in the lower court. Okay, so the subordinate courts at the district level also decides the various cases in the lights of the judgment handed over by the High Court of the different states. Okay, and like this, High Court also has a right to transfer the cases. That means it can transfer the cases from a subordinate court to itself, and it can take up the following action. That is, it can either take up the cases by itself, or it can send to the other court, that means to the subordinate courts after deciding, or it can keep it itself. Okay, so like this, these are some of the powers and functions of the High